Legal authority. Do we have to do that, sir? I would defer the questions on legal authority to the Attorney General and the Department. Fair enough. D 31 minutes. That is how long Kash Patel stayed on the phone with the law firm on February 28th. Private call, no official log, no staff present. 31 minutes with attorneys who represent 3 of the 38 individuals named inside a classified FISA surveillance file. And then 13 days later, Patel used the full authority of the FBI. Directorship to seal 140 pages of surveillance records, pull them from the release queue, and bury them so completely that it took a whistleblower to get them out of the building. Senator Lindsey Graham walked into that hearing room with the phone record, the sealing directive, and the internal memo that FBI's own legal unit wrote when they realized what had just happened. He didn't need to editorialize. He didn't need to raise his voice. He just needed to put those 3 documents on the table in front of Kash Patel and ask one question that had no safe answer. Of the 38 people named in that sealed file, the 38 individuals documented in 1,840 pages of FISA surveillance records that Patel personally classified and locked away. How many are still serving in the federal government right now? Stay with me until the very end, because Patel's answer to that question and what he did instead of answering it is the moment this hearing broke open. The Senate Judiciary Committee had been in session for nearly 2 hours when Graham took the microphone. He is not a senator who needs a long runway. After decades in the chamber, after years on the armed services and judiciary committees, after enough hearings to recognize every deflection technique in the professional witness playbook, Graham moves with the efficiency of someone who has already done the work and just needs the record to reflect it. He is also critically a Republican, a member of Patel's own party, a senator with no obvious political incentive to spend his allotted time dismantling the FBI director's credibility. That fact was not lost on anyone in the room. When a Republican senator leans forward and says quietly without performance, "Director Patel, I have something I need to show you," the room understands immediately that what follows is not partisan theater. It is something worse for the witness. Graham placed 3 documents on his desk. He didn't hold them up for the cameras. He didn't announce them dramatically. He just laid them flat in order and looked at Patel with the expression of a man who has been disappointed before and is about to be disappointed again. "Director Patel," he began, "I want to walk through something with you. I am going to describe 3 documents, and I am going to ask you to tell me if my description is accurate. Can you do that?" Patel nodded. "Of course, Senator." "Good. Document 1, a FISA surveillance file, 1,840 pages, compiled over a period of approximately 14 months, documenting electronic surveillance of 38 individuals under court-authorized foreign intelligence collection. Do you know which file I'm referring to?" A pause, not long, but measurable. "Senator, there are numerous FISA-related files within FBI systems. Without a specific case number, couldn't I have the case number?" Graham slid the first document across his desk toward the camera. "I also have your signature on the sealing directive. So, let me ask again. Do you know which file I'm referring to?" The room went very still because everyone present understood what Graham had just done. He hadn't asked Patel if the file existed. He hadn't asked whether the sealing directive was real. He had demonstrated before Patel said a single word in response that he already possessed both documents, that the question was not a fishing expedition, that there was no version of this exchange in which Patel could claim. The documents didn't exist because Graham was already holding them. Patel's lead attorney leaned in, a whispered exchange that lasted about 4 seconds. Then Patel straightened. "I am aware of FISA materials that have been classified under director-level authority." "Classified," Graham repeated. "You used the word classified. The directive I have in front of me uses the phrase sealed and restricted from further review pending permanent archival designation." He looked up. "Director Patel, that is not a classification decision. That is a burial order. There is a difference." Patel's jaw tightened. The specific procedural designation used in any given directive reflects legal guidance from Graham interrupted. Not sharply, just directly. "Whose legal guidance?" Silence. "Let me move to document 2, Graham said. February 28th of this year. A phone call placed from your personal cell phone to Hartwell Breer and Associates, a private law firm based in Washington. 31 minutes. Can you confirm that call took place? Here is the moment you need to understand, because Patel had two options. When Graham asked about the February 28th call, he could confirm it, which meant explaining what was discussed with a firm that represents 3 individuals named in the file he sealed 13 days later. Or he could deny it, which meant contradicting a phone record that Graham was already holding. There was no third option, and Patel knew it. "I communicate with numerous attorneys in the course of my responsibilities," he said finally. "I cannot confirm or deny specific calls without reviewing my communications logs." Graham nodded slowly, the nod of a man who expected exactly that answer and prepared for it. "I'll review it for you." Hartwell, Breer and Associates, February 28th, 31 minutes. He held up the phone record. And here is what makes that call significant. Director Hartwell, Breer and Associates currently represents 3 of the 38 individuals named inside the FISA surveillance file. You sealed 13 days later. The room erupted, not loudly, the controlled eruption of journalists typing simultaneously, of committee staffers exchanging urgent glances, of every person present doing the same calculation at the same moment. 31-minute call. 3 clients in the sealed file. 13 days. 1 burial order. Senator Patel said, his voice careful now in a way it hadn't been before. Any suggestion that a private legal consultation influenced an official classification decision is I haven't suggested anything. Graham said, I've stated a timeline. The suggestion comes from the timeline itself. Stop right here. If you've been watching and you're beginning to understand what Graham just constructed in that room, hit the like button right now, because this is the architecture of accountability that most congressional hearings never reach. Graham didn't accuse Patel of anything. He didn't need to. He laid 3 documented facts in chronological sequence and let the distance between them speak. February 28th call to a firm representing people in the file. 13 days later, file sealed. That gap 13 days is the entire argument. Because if the sealing decision was routine, if it was based on standard classification review with no connection to the February 28th call, then Patel can explain it. He can describe the process. He can name the career officials who recommended the decision. He can produce the paperwork showing the legal basis. He hasn't done any of those things. And the reason he hasn't done any of those things is the same reason Bondi went silent for 83 seconds. The same reason Razan's question about who is being protected produced 11 Fifth Amendment invocations. The same reason Kuhn's timeline of 47 minutes and 14 closed investigations went unanswered. Because the answer is worse than the silence. Graham moved to the 3rd document, the one that came from inside the building. Director Patel, I want to ask you about a memo prepared by FBI's Office of General Counsel on March 14th, 4 days after your sealing directive was issued. This memo was prepared by career attorneys, not political appointees, and it was transmitted through internal channels to senior leadership. He held it up. I obtained this document through a whistleblower who believed it was being suppressed. I want to read one sentence from it. He read slowly. The March 10th directive sealing case file designated FISA 2024 BR 000047 raises procedural irregularities that counsel believes require review by the Inspector General as the directive does not conform to established classification protocols and may constitute an improper use of director-level authority. He set the memo down. Procedural irregularities, improper use of director-level authority. Those are the words your own career attorneys used to describe what you did. Graham looked at Patel steadily. What happened to the attorneys who wrote this memo? The silence lasted 8 seconds, long enough for everyone in the room to understand that the answer was not going to be that they were promoted and commended for their diligence. Personnel matters are handled through appropriate internal processes. Were they reassigned? Staffing decisions reflect operational requirements. Director Patel, yes or no? Were the attorneys who formally documented concerns about your sealing directive subsequently removed from their positions? Another pause. Some personnel changes occurred in the relevant office after they wrote this memo. Not a question, a fact in the record. Permanent. But here is where Graham arrived at the center of everything. The question he had been building toward since the moment he placed those 3 documents on his desk. The question that made every prior exchange look like foundation work. Director Patel, I want to ask you about the 38 individuals named in that sealed file. 38 people documented in 1,840 pages of court-authorized surveillance. People whose activities were considered significant enough to warrant federal intelligence collection over 14 months. Graham leaned forward slightly. How many of those 38 individuals are currently serving in the federal government? The room went completely quiet. Not the shifting, rustling quiet of people waiting for a routine answer. The absolute stillness of people who have just heard the question that the entire hearing had been moving toward and suddenly understand why it matters more than everything that came before it. Because that question is not about the past. It is about right now today. The 38 people in that sealed file, the people whose surveillance records Patel buried in a permanent archival designation 13 days after calling a law firm that represent 3 of them, are not necessarily historical figures. Some of them may be sitting in federal offices at this very moment, making decisions, holding clearances, accessing sensitive information, serving in positions of public trust, while 1,840 pages documenting their activities under FISA court authorization sit sealed in an FBI vault that Kash Patel locked and handed the key to no one. Director Patel, Graham said again, his voice very quiet now. How many of those 38 people are still in the federal government? Patel's attorney leaned in. The whispered exchange lasted longer this time, nearly 10 seconds. When it ended, Patel straightened and looked at Graham with an expression that had moved past professional composure into something that looked almost like exhaustion. Senator, I cannot discuss the identities or current status of individuals named and classified FISA materials in an open setting. I'm not asking for identities. I'm asking for a number. Any number I provide would necessarily implicate classified. A number, director, not names, not positions, not agencies, a number. Of the 38, how many are currently federal employees? The silence that followed was the longest of the entire hearing. Graham waited. He did not fill the silence. He did not rephrase the question. He did not offer Patel an easier path. He simply waited with the patience of a man who has been in enough rooms to know that some silences are more eloquent than any answer. Patel did not answer. I want the committee to note, Graham said finally that the FBI director, when asked how many individuals documented in a sealed surveillance file are currently serving in the federal government, declined to provide even a number, not names, not details, a number. He gathered his papers. The American people can draw their own conclusions about why that number is something the director of the FBI cannot say out loud. Here is what the timeline tells you. February 28th, 31-minute call with a firm representing people in the file. March 10th, 1,840 pages sealed under a directive that Patel's own attorneys called procedurally irregular. March 14th, career lawyers formally document concerns. Days later, those lawyers reassigned and sitting inside that sealed file right now today, an unknown number of individuals who are still drawing federal paychecks, still holding federal clearances, still operating inside the government. While the documentation of their surveilled activities sits locked away in a vault that Patel sealed and refused to discuss under oath. That is not a classification decision. That is a protection decision. And the 31-minute phone call that preceded it by 13 days is the thread that, once pulled, unravels every justification Patel has offered for why those 1,840 pages cannot see the light. Lindsey Graham, a Republican senator, a member of Patel's own party, put that thread on the congressional record today. He didn't accuse. He didn't editorialize. He just laid the timeline down and asked for a number that the FBI director of the United States could not bring himself to say. Subscribe right now. Hit the bell. Share this video. Because the whistleblower who brought that internal memo out of the building is not the only one watching. The Inspector General referral that Graham announced at the close of the hearing is now moving through official channels. The 38 names in that sealed file are the next question that Washington cannot avoid. And the 31-minute phone call on February 28th is the answer that Kash Patel just refused to give. 13 days between the call and the burial order. That gap is the hole.